A very good morning. A very good morning to one and all present here. I quote, to deny people their human rights is a challenge to their every humanity. Nelson Mandela. Good morning to one and all for joining this SCL webinar series on the topic Social Security to Unorganized Workmen. Now, I request our beloved principal, Dr. BP Mahesha, to introduce the guest speaker. Over to you, sir.
Very good morning to one and all. It's my privilege to introduce a well-known professor in India, Professor Dr. V. Sudesh sir. Professor Dr. V. Sudesh sir is an alumnus of Bangalore, completed BA LLB degree in the year 1991, Masters in Law in the year 1993 from University Law College, Department of Studies in Law. He has completed his PhD under the valuable guidance of V.B. Coutinho, a professor of law, former Vice-Chancellor, Gulbarga University, Gulbarga. Sir is having more than 27 years of teaching and research experience. At present, there are a good number of students who are doing PhD under his guidance. As on today, there are 10 students who have completed their PhD under the able guidance of Professor V. Sudesh sir. He has served as a officiating Vice Chancellor of Bangalore University, Dean, Faculty of Law, Chairman, Principal, University Law College, Bengaluru University, Bengaluru. Sir has presented more than 100 articles, research articles in national and international conferences. Sir, on behalf of Soundarya Education Trust, Soundarya College of Law, and all the persons who are present in this webinar, I welcome you, sir.
Thank you.
It's my privilege to welcome our Chief Executive, Mr. Kirtan Kumar sir, a person inspiring all the faculties, who is always supporting all the activities of our institutions, sir. On behalf of the organizer, I welcome you, sir. I also welcome teaching, non-teaching faculties of Soundarya College of Law, and also the students of Soundarya College of Law and other person who are present in this webinar. This webinar is going to throw light on the various provisions relating to protection of unorganized workers. Once again, I welcome one and all to this webinar. Thank you and good day. Priya ma'am. Sir, you can start the presentations.
Fine.
So now I request our guest speaker, Dr. Sudesh sir, to start the webinar series.
Okay. Hope my screen is visible.
Yes, sir.
Fine. 1 minute. I will just maximize this. Okay. Fine. Good morning, one and all. The principal of Soundarya College of Law and a very good friend of mine, student of mine, Dr. BP Mahesh, the CEO of Soundarya College of Law, Sri Kirtan Kumar sir, the esteemed teaching members of the Soundarya College of Law, most of them students of University Law College, Madam Priya, who introduced me, colleagues in the Soundarya College of Law, and my dear students. At the outside, let me present the synopsis of my presentation on the topic social security for the unorganized workers in India. Well, we will first begin with a brief introduction. Then we will know what the International Labour Organization has recommended or what conventions it has passed to protect the interests of the unorganized workers. We will discuss into the various categories of unorganized workers, the legislative provisions that have been made for the unorganized workers, the new social security code, which recently the government of India introduced, and the judicial response. This is how my presentation for the day has been divided. Well, friends, to begin with, let me throw light on a brief history of the working class. The modern working class, as we know now today, has an history. The history is the outcome of industrial revolution. It grew under the colonial era in India. Throughout the British colonial period, workers in unorganized small-scale units outnumbered those in modern factories, mines, and railroad constructions. In fact, the statistics available of the year 1911 states that in the year 1911, 95% of the industrial workers were employed in units other than registered factories, meaning that there are 95% unorganized workers. So what distinguishes the category of unorganized workers from organized workers is the sheer number, the number of people employed, because the organized sector was in fact demanded huge pools of work. These workers were required to work in textile industries, in mining industries, in building the railways, in cotton textile productions, etc. So each industry needed a sizable number of workmen. So when they came together collectively, they were initially, the term was called as organized because they were all employed by one single employer. Now, what distinguished at that time organized from unorganized workers is that there were other employers who needed small pool of workers. And these small pool of workers who migrated from rural areas in search of odd jobs in urban areas, concentrated as the unorganized workers, because these people came, worked during off season when there were no agriculture activity, or if the agriculture production had come down, they used to come to the cities, work, go back. In that sense, it was categorized as organized and unorganized. Of course, the modern understanding of unorganized is a little different in the sense of the nature of employment. Let us look into that. Anyhow, before going to that, let us see what the International Labour Organization has said about the social security aspect of the unorganized workers, or in general also. To start with, let me tell you that the ILO, the International Labour Organization, established in the year 1919 after the end of the First World War as a result of the Treaty of Versailles, was the first international tripartite body which was entrusted with the task of promoting workers' interest. So the ILO comprised of employers' representatives, governments' representatives, and employees' representatives. From 1919 to 2019, the International Labour Organization has completed 100 years of its existence, and it has passed several conventions and recommendations which each member country has to ratify as and when it is enacted. So from the point of view of the ILO, social security is a human right which responds to the universal need for protection against certain life risks and social needs. Effective social security system guarantee income security and health protection. So there is income security and health protection, thereby contributing to the prevention and reduction of poverty and inequality. So two objectives that the social security system tries to achieve is to reduce poverty and reduce inequality, and the promotion of social inclusion and human dignity. Most important, social inclusion and human dignity. They do so through the provision of benefits. How does the social security system come about? Through the provision of benefits, either in cash or in kind, which is intended to ensure access to medical care and health services, as well as income security throughout the life cycle of the workers, particularly in the event of illness, unemployment, employment injury, maternity, family responsibility, invalidity, loss of the family breadwinner, as well as during retirement and old age. That is the wholesome objective of a social security system. So what we understand is that the International Labour Organization has elevated the right of social security to that of a human right, which means that it is universal need for the workers. Further, social security systems therefore constitute an important investment. It is not an expenditure. It's an investment in the well-being of workers and the community as a whole, and facilitate access to education, to vocational training, to nutrition, to essential goods and services. In relation with other policies, social security contributes to improving productivity and employability and to economic development. See the three important connections which social security system has got to improve productivity, because a worker who is well protected medically or during his work will produce more, will be in a productive body structure, he will be employable, and this will lead to economic development. For employers and enterprises, social security helps to maintain a stable workforce that can adapt to changes. Otherwise, people may not come to work. In the early part of the Industrial Revolution, employers did not need, or employers did not care for the so basic needs of a worker. So many used to fall sick, meet with accidents, and they used to go back to their hometown in rural areas, never to return. So this way, the workforce was unstable. Now, social security system guarantees that the workforce is stable. Finally, it reinforces social cohesion and therefore contributes to building social peace, inclusive societies, and a fair globalization by ensuring decent living conditions for all. Now, mark by those words: decent living conditions for all. A social security system ensures decent living conditions for all. Now, let's move on to understand who are these unorganized workers. Just a couple of slides back, I told you the history of the workers in India, how initially they were called as organized because you required a large pool of workers, or they were called as unorganized because they came, they worked and left. Picking up from there, we understand that unorganized workers are those who have not been able to organize themselves in pursuit of common objectives on account of constraints like casual nature of employment. Because they're casually employed, they cannot come together and say, for example, demand higher wages, demand leave, demand other benefits. They cannot come together with casually employed in a casual nature of employment, or because they're ignorant, illiterate, they're small, and their scattered size of establishment and positions of power enjoyed by employers because of the nature of industry. So when we speak about unorganized workers, we must remember these people lack the efforts to organize themselves to pursue common objectives of them, common objectives of the workers, because of the nature of employment or because of the powerfulness of the employers. With that definition, we understand that the ILO has done much. I told you about ILO. ILO has got several conventions and recommendations. There are several. I've only quoted a few here for the sake of a brief understanding. These conventions, like the Social Security Minimum Standards Convention 1952, which India has ratified, the Equality of Treatment Social Security Convention 1962, the Employment Injury Benefits Convention 1964, the Invalidity, Old Age and Survivors Benefit Convention 1961, the Medical Care and Sickness Benefit Convention 1969, the Maintenance of Social Security Rights Convention 1982, the Employment of Promotion and Protection Against Unemployment Convention 1988. These are a few of the social security conventions which are passed by the ILO, which countries adopt and translate into specific legislations in their own legal system. So therefore, I said earlier that ILO is an institution which carries forward the workers' rights by passing conventions recommendation, which each member nation has to ratify. What does the government of India say? The Ministry of Labour, Government of India has categorized the unorganized labor force under 4 groups. These groups are classified in terms of occupation, in terms of nature of employment, and then whether they are distressed categories or service categories. Let us look into each one of them. The categorization in terms of occupation includes small marginal farmers, landless agriculture laborers, sharecroppers, fishermen, and those engaged in animal industry, beedi rolling, labeling, packing, building and other construction workers, leather workers, weavers, artisans, salt workers, workers in brick kilns and stone quarries, workers in sawmills, oil mills, etc. Some of the occupation, if some of the workers are employed in these kind of occupations, they are categorized as unorganized workers. And then, depending upon the nature of employment, whether they are agricultural laborers or bonded laborers or migrant workers, contractual basis, casual laborers, they are also categorized under unorganized workers. Then in terms of distress category, they are very poor, like toddy tappers, scavengers, carriers of head loads, drivers of animal driven vehicles, loaders, unloaders belong to the distress category. Similarly, to the service category, like domestic workers, midwives, fishermen, women, barbers, vegetable vendors, fruit vendors, newspaper vendors, some under this come under the service category. Of course, we have 2 other new category which has included, about which I will discuss later: the gig and the platform workers. Now, in addition to above categories, there exists a large section of unorganized labor force, such as cobblers. What I gave was in terms of the nature of employment, the occupation, etc., or the service they are doing. Now, apart from this, those who do not fall in any of the above categories are the totally large who work on their own, like cobblers, hamals, handicraft artisans, handloom weavers, tailors, lady tailors, those who do not work with any garment industries, lady tailors, physically handicapped self-employed person, rickshaw pullers, auto drivers, sericulture workers, carpenters, leather and tannery workers, power loom workers, and urban core. huge list of workers who come under the unorganized sector. Now, therefore, now you will be not surprised that in India, latest estimate, latest census report, NSSO says that 93%, around 400 million workers are in the unorganized sector. Now, the fun here is that it has reduced only by 2%. I said in 1911 it was how many percent? 94% were in unorganized sector. Post-independence, latest is it is 93%. Around 4 million workers are working in the unorganized sector. Now, the fun that I was talking about is all your labor laws that you have already studied or you will be studying in the coming semester is for the organized sector, who are only about 7 to 8%. That's the problem here. Therefore, we will now discuss what are the legislative provisions for the workers. Now, before we discuss the legislative framework for the workers, you must understand that labor is in the concurrent subject in the Constitution of India, meaning that both, as you know, if it is the concurrent subject, union government, that is the central government, and the state government are competent to legislate on labor matters and administer the same. The bulk of important legislative acts have been enacted by the parliament. The majority, around 38 to 40, I think it should be 44 central legislations are there, and more than, if you include all states, more than 400 state legislations are there. Now, the legislations can be categorized as follows. Labor laws enacted by the central government, where the central government has the sole responsibility for enforcement. For example, the Industrial Disputes Act, the Employment Standing Orders Act. Labor laws enacted by the central government and enforced both by central and state governments. For example, the Building and Other Construction Workers Act 1986. Then there are labor laws enacted by central government and enforced by state government, where the central government will, for example, interstate migrant workers, enacted by central government, but has to be implemented by the state government. Labor laws enacted and enforced by various state government, which apply to respective states. So within the state, you have the Domestic Workers Act and you have several such legislation which each state government do. So if you look at all these 4 categories of legislation, we find that there are hardly few which are applicable to the unorganized workers. The law which could facilitate the cause of the unorganized sector may be divided under the general and special class. Now, the 4 or 5 categories of legislative framework that I discussed in the previous slide could be categorized into general class and special class. The former enacts cover both organized and unorganized. The general class labor laws protect both organized and unorganized, depending upon the interpretation of the codes. Whereas the unorganized laws cover specially applicable for certain classes of unorganized workers, like it could be domestic workers, cine industry workers, building other construction workers, manual scavengers. These are special class only applicable to unorganized workers. What are they? We will just look into it. General legislation, which are applicable for both by way of its implication, implementation, or by way of court judgments. So although prima facie, it does not cover the unorganized sector, but these laws should be considered as the unorganized workers come within the purview on the basis of the enacted provision supported by judicial interpretation. For example, the Employees Compensation Act 1923, which was previously known as the Workmen's Compensation Act. It is a pre-independent legislation which was enacted by the British Indian government after a convention in this regard was made by the ILO. All of us know, if you have already studied this Employees Compensation Act 1923, the law basically aims at providing compensation for workmen in cases of industrial accidents, occupational diseases resulting in disablement or death. So basically, the Employees Compensation Act 1923 compensates a worker if he dies or gets injured during and out of the course of employment, or if he contracts an occupational disease which is categorized as an occupational disease under the schedule of the act. So either if he's disabled or death, he gets a certain amount of compensation which is calculated as per the calculation given in the act itself. So what we understand is the Employees Compensation Act, though these acts are implemented in factories and large establishments, nevertheless, it could be still applied to unorganized workers where the nature of work is such that accidents are bound to arise. For example, if you remember a case law wherein a salt manufacturing, by-value salt manufacturing company case where the salt manufacturing workers had to cross a creek by using a boat sort of a thing, which one day, because of overloading, tilted in the midstream and many people lost their lives. Though they were all unorganized workers, the court held that it was an accident arising out of and in the course of employment and they had to be compensated. So many such case laws you learn to know that the Employees Compensation Act applies to unorganized workers in case of accident arising out of and in the course of employment or contracting an occupational disease. Then we have the ESI Act, which provides for health care and cash benefits in the case of sickness, maternity, and employment injury. Depending upon the strength of the establishment, the Act is notified. And once the Act is notified for a particular establishment, the ESI deductions have to be made, and then the benefit is given to the worker. Then we have the Employees Provident Fund and Miscellaneous Provision Act 1952, which provides for compulsory provident fund, pension, deposit linked insurance. We have the Maternity Benefit Act, which provides for maternity protection before and after childbirth. We have the Payment of Gratuity Act 1972 to provide for payment of gratuity on ceasing to hold office. So those were some of the general legislation, only few I have discussed. Those were some of the general legislation which may be applied even to unorganized workers if the nature of the unorganized worker is covered by the definition of worker or the definition of the establishment, or if the court through its order directs the law to be implemented. Then we have the special legislation. Why these are called special legislation is because these laws are designed only for the unorganized class. For example, the contract workers. Contract Labor Regulation and Abolition Act 1970. It aims to regulate the employment of contract labor in every establishment employing 20 or more workmen, and also to provide for its abolition in certain circumstances. You know that many of the industrial establishments employ workers on contract basis. They employ workers through a contractor. There are several litigations in the courts of law wherein the employer, principal employer, has declined to give any compensation in the case of death or in other cases of disablement to a contract employee just because he was a contract employee. He was employed by the contractor by submitting that he is not directly employed by the principal employer. Therefore, the courts in several judgments have classified and said, wherever the work is of a perennial nature, continuous nature, and in those continuous nature of employment, if the employer employs contract labor, they should be considered as permanent labor, and they should be covered under the benefit of the various legislations. Similarly, we have the Interstate Migrant Workmen Regulation of Employment and Condition of Service Act 1979. Now, this is an act which provides the employment of interstate migrant workmen and to provide for their conditions of service. If you remember, the lockout, the lockout induced because the COVID-19 1 and 2, You have seen several, especially during the first lockdown, several workers traveling to their hometowns and on bicycles, on motorcycles, by walk, on road, walking on the tracks. Now this law actually is enacted for the interest, for the protection of the interest of these kind of migrant workers who move within the state or out of the state. The law was enacted with a view that the people who are employed as migrant workers must be given minimum uh, compensation for traveling to the place of work, and in case they want to return to their hometown, the traveling cost. This law was enacted to provide some shelter to be provided to the migrant workers at the workplace, and various other provisions are there. So basically, the the lockdown has made it known to the whole world how these people suffered, and therefore they were categorized unorganized workers, a specific law for their purposes. Similarly, we have the BD Workers Welfare Fund Act 1976, which is an act to provide for the financing of measures to promote the welfare of persons engaged in BD establishments. We have the Building and Other Construction Workers Regulation of Employment Conditions of Service Act 1996. This is an act again, as I told you, that many construction activities post-globalization, many construction activities have taken place. This is an act which regulates the employment and condition of service of building and other construction workers, and to provide for their safety, health and welfare measures, and for other matters connected therewith or incident health. So this is a law which has got, which according to which every state government has to constitute a welfare fund. A welfare cess has to be deducted from all contractors, all persons who are engaged in the construction of building, railroads, bridges, etc., any building. From them, a certain percentage cess has to be collected. That cess has to be deposited in the welfare board. The welfare board is to be administered by the labor department in the state government, and the funds which are collected has to be used for the welfare of the construction workers, either for their medical benefit, or for the education of the children, or for the marriage of the children, or for buying tools, etc., etc., etc. So what is surprising is, though the law was enacted in 1996, until 2011-12, not all state governments had established the welfare board and were not collecting the welfare cess. Only when a public interest litigation was filed in this regard, somewhere in the year 2011-12, the Supreme Court directed the central government and all the state governments to constitute the welfare board and collect the funds and use it for the welfare of the construction workers. Similarly, we have the one enactment which tried to overcome all other specific legislation which was specifically enacted to target the unorganized workers, is known as the Unorganized Workers Social Security Act 2008. Finally, this law was enacted for providing social security to the unorganized sector. What was the remarkable provisions or features of this law? It provides for framing of schemes by the central as well as state government and funding of central government schemes. To achieve its objectives, there is a provision for the constitution of the board at the state level, and also the funding of state government schemes for record keeping by district administration and for setup of the workers facilitation center. It empowers the government at the central as well as the state level for framing the rules. All unorganized sector workers above 14 years are entitled to register themselves and receive a smart identity card. By registering themselves, by paying a nominal fee, an unorganized social security worker would get benefit and use that identity card wherever went, to whichever state he went. So this Unorganized Social Worker Security Act 2008, the problem with the implementation of this law was Not many workers knew about it. Even if the workers knew about it, there was no procedure for registration. Even if there was a particular procedure for registration, the workers were unaware. And because the unorganized workers who move from one state to another state, they are reluctant to register because they feel that by paying a certain amount, even 100 rupees or whatever nominal amount is fixed, they would be wasting. They're not aware of the benefits of this particular law. So therefore, what we find is the unorganized worker social security 2008 was not so much successful. We'll see what are the changes made in the next discussion. Now let us come to the judicial response. Judiciary in India, as all of us know, has done a commendable work in terms of protecting the rights of the workers. We had great judges like Justice Krishna Iyer, Justice Gajendra Gadkar, and many other judges who implemented the true spirit of the Constitution in protecting the workers' right, be it organized or unorganized. Various articles introduced in the Constitution of India to secure the rights of the workers, whether it is provision for social security, whether it is entitlement for minimum wages, whether it is prohibition of exploitation of labor, whether it is directions for the state government through the directive principles of state policy to implement such measures, the Supreme Court has been at the forefront in implementing all these provisions for the welfare of the workers. Because ultimately, the object of Social Security is to ensure that everyone, each and every worker, has the means of livelihood. It follows, therefore, that the right to Social Security is also inherent right in the right to life. We can read right to Social Security within the right to life under Article 21. Let me take you to one of the earliest and one of the oldest cases which arose the consciousness of the society, which tried to protect the rights of the unorganized workers, especially the construction workers. That is the People's Union for Democratic Rights versus Union of India, year 1982. If you remember, if you go back to history, you will know that during 1982, the government of India was planning to host the Asian Games at that particular time. Now, Asian Games required that several Asian Game village complexes, sports complexes had to be constructed. For this purpose, the government of India awarded contract to several contractors. These contractors, known as Jamadars, brought workers from different parts of India. They wanted skilled workers from Gujarat, from Rajasthan, from UP, from Bihar, and engaged these workers for the construction of bridges. What was actually happening was that, number one, that the workers were paid less than the minimum wage. Number two, the women construction workers were paid a little less than the male workers. Number three, there was no provision made for all these migrant workers to stay in a proper accommodation. Number four, even children were employed along with their parents. So taking up all this allegation, a PIL was filed by the People's Union for Democratic Rights. The Union of India came up with this argument that a PIL cannot be entertained on behalf of the workers because the workers have to come to the court alleging all these things, number one. Number two, they said, in any case, we have not directly employed them. These people are employed by the contractors, and whatever the minimum wage, we are paying it to the contractors. The contractors not paying it to the workers, so therefore we are not responsible. The Supreme Court very emphatically said that employing workers and paying less than the minimum wage would attract Article 23. Article 23 prohibits employing workers for wages Article 23 is the heart and soul of the workers' right, which seeks to protect exploitation of workers. Article 23 speaks about prohibiting forced labor. More so, when the government itself has engaged the contractors, it is directly responsible to mitigate the hardship of the workers. It is directly responsible to fulfill all the mandates of the minimum wage law. So therefore, we find that in this particular case, the Supreme Court for the first time came to the rescue of the workers and entertained a PIL. It said, you cannot ask, you cannot expect a worker to come to this court because, first of all, he may not be aware of it. Secondly, he may be illiterate. And thirdly, where is the time for him to come to the court? In such cases, a public interest litigation is maintainable, is what the court said. Another important case in this direction is a landmark judgment in 1983 in the case of Sanjit Roy versus State of Rajasthan. In this case, the court held that payment of anything less than the minimum wage to all workers, including the famine relief workers, is to be considered as forced labor and a violation of Article 23 of the Fundamental Rights of the Indian Constitution. What happened was, in this case, the government initiated measures for famine relief because there was famine, people did not have work. Famine means that workers did not have money, workers did not have job to earn, they did not have money to buy food. So the government said, anyhow, we are giving them work. So what if they are paid less than the minimum wage? The court said categorically, nothing doing. Anything less than the minimum wage to all workers, even though it is under the famine relief work, is to be considered as forced labor, and it is a violation of Article 23. We also find another peculiar case, an older case, 1958, that is the Crown Aluminium Works versus their workmen. In this case, the constitutional validity of the minimum wages was challenged. The court said the motivation of the legislature for enactment of Minimum Wages Act is that, in its own words, the court's words, in a developing country like ours, which faces the problem of unemployment on a very large scale, it is not unlikely that a labor may offer to work even on starvation wages. But the policy of the Act is to prevent employment of sweated labor in the general interest. And so, in prescribing minimum wage rates, the capacity of the employer need not be considered, as the state assumes that every employer must pay minimum wages for the employee's labor. A fantastic judgment. What happened in this case was the employer challenged, said a notification of the Minimum Wages Act, and so we cannot pay so much. Because, number one, he said, the workers are happy to work less than the minimum wage. They are accepting our wages, so there is no grievance. Number two, we cannot pay the minimum wage. If we pay the minimum wage, we will not be able to earn any profit. Number three, in any case, in this particular industry, in this particular region, no one is paying the minimum wage or above what we are paying. So therefore, it's an unreasonable restrictions on the right to carry on business, profession, etc. But the court said, no, nothing doing. The objective of the Minimum Wages Act is to prevent workers working on starvation wages. You cannot allow workers to work on half wages. You cannot allow workers to work on half stomach. Therefore, in any case, the employer is taken up. It is assumed that when an employer takes up an industrial activity, he has the power, he has the financial capacity to pay the minimum wage. That was a very beautiful judgment given by the Supreme Court in the year 1958. Then, another case, the Gammon India Limited versus Union of India. The Supreme Court, while dealing with the object for which the Contract Labor Regulation and Abolition Act was enacted, observed that the Act was passed to prevent the exploitation of contract labor and also to introduce better conditions of work. The Act provides for regulation and abolition of contract labor. I've told you earlier that you cannot employ contract labor in perennial work, in a continuous work. So the underlying policy of the Act is to abolish contract labor whenever possible and practicable, and where it cannot be abolished, the policy of the Act is that the working conditions of the contract labor should be so regulated as to ensure payment of wages and provision of essential amenities. So the whole objective of the contract labor is, first of all, to prevent the abuse of workers' right by employing them on contract as contract laborer on such work which is of continuous perennial nature, and secondly, to regulate their condition. Even if they're on contract labor, minimum wages must be paid. Now, let us come to the changes that have taken place in recent times. As labor law students, you must be aware that four new labor codes have been enacted on industrial relation, on social security, on wages, on trade union, etc. I am speaking about the new Social Security Code. The new Social Security Code 2020 was passed by the Parliament. The state governments have been directed to frame rules in the under the new Social Security Code, and so that it becomes applicable to all workers. The Code on Social Security subsumes 9 central labor legislations. So the law that we studied earlier, the Employees Compensation Act, the ESI Act, the Provident Fund Act, the Employment Exchanges Act, and the Maternity Benefit, or the Payment of Gratuity Act, the City Workers Welfare Fund Act, the Building and Other Construction Workers Act, and the Unorganized Workers Social. All these laws, 9 laws, is now codified into a single law known as the Code on Social Security 2020. What is the objective of this code? The objective of the Code on Social Security is to amend and consolidate the existing labor laws relating to Social Security. I just now in the previous slide, so many laws on Social Security, each having different objectives. Now with this new Social Security Code, all these have been consolidated with what idea? With the wider goal of extending Social Security benefits to all employees and workers, irrespective of whether they belong to the organized or unorganized sector. So the objective is, I told you that all the laws most of the labor laws are applicable only to 8% of the organized workforce. So the 92 or 93% of the unorganized workers left without any remedy. Even if those remedies are there, those legislative frameworks are there, they're not applied to them. To overcome this drawback, this Code on Social Security has been enacted. Now, the Code on Social Security 2020 brings within itself the self-employed workers, home workers, wage workers, migrant workers, the workers in the unorganized sector, gig workers, platform workers, for the purpose of Social Security schemes, including life insurance, disability insurance, health and military benefits, and provident fund. So what we understand from the intention of the Act is a wide variety of unorganized workers are covered to benefit from this particular law. Home workers, home-based workers, wage workers, migrant workers, a whole lot of people who were earlier not covered under any law, they are now to be covered under this law, pending the framing of the rules. Now, the Social Security Code defines various terms as, now who is responsible for all these things? Who is gig worker? All these things are defined under the law. Aggregator, who is a gig worker? Who is a platform worker? Who are unorganized workers? For example, the home-based worker and the self-based worker. Further, the definition of the employee has been widened to include a maximum number of employees and workers, because the earlier labor legislation restricted itself with the general trend is 10 or more, 20 or more, with power, without power. The definition of factory, if you go read the Factories Act 1948, you'll know that 10 or more with power, 20 or more without power is a factory. All these things have been overcome under the new social security law. I was talking about a new categories of workers who are creeped into the nature of unorganized workers. And these are known as the gig workers. So the gig is a term which is actually borrowed from the French. The gig people are those who perform who stand alone and perform music. From there, they stand alone. They're one-time performance. For example, if you have seen people singing on pavements, playing music on the pavements for some short time, collecting some money and going away. That is the origin of that particular term gig. So what is a gig worker? The code defines a gig worker as a person who performs work or participates in a work arrangement and earns from such activities outside of traditional employer-employee relationship. Your Zomato delivery boy is an example of a gig worker. Normally, a gig worker means a person who performs a job temporarily, or someone who takes up part-time jobs on hourly basis. People who graduate out of college, people who come out of school, they may take a temporary employment as delivery boys. So all the delivery boys perform their work for some time and may shift to other employment, or may come back to study, or may not do at all work, or may go back to agricultural life. These are gig workers. So the concept of gig workers have been introduced for the first time under the ambit of labor laws. It was the need of the hour, as all of us know, because such categories of workers are not covered under any of the beneficial labor laws. Looking into the conditions of their work, they work under sun, under rain, under gusty winds, on bad roads, they meet with accidents, the problems of work, the employers removing them from workers if they don't get good reports. There are problems they face from customers abuse, etc. So gig worker is a new phenomena in India, at least in the past 10 years. In the past 2-3 years, they have been everywhere because of the COVID pandemic situation. You have employed them at various points of time. Similarly, the platform workers, the code defines, the Social Security Code defines platform worker as a person engaged in or undertaking platform work. Most commonly, platform-based worker is where workers earn money by providing specific services or to solve specific problems through online platforms such as Amazon and Flipkart. When you order goods on Amazon, when you order goods on Flipkart, when you request services on Amazon, when you request services on Flipkart, they will send some person either to deliver the goods or to perform. So there are several such online platforms where your Ola drivers, your Uber drivers, all these car drivers, they're all employed to a certain platform. So therefore, they're known as platform workers. So under the Social Security Code, even these workers, platform workers and gig workers, are to be covered to provide the beneficial aspects of the Social Security Code. As there were no specific legislation for the unorganized workers, they cannot claim significant benefits like minimum wage. There's a problem of unorganized workers. The problem of unorganized worker is they cannot claim minimum wages. There is no fixed hours of work. There is no payment for overtime work. There is no leave. Your gig and platform work, is there any overtime or leave? No. The new code introduced the same opportunities and protection which is given to other employees, like for example, the government employees or private sector employees under various labor laws in India. So the Social Security Code 2020 hopes to revolutionize the entire workers' rights as far as the unorganized workers are concerned. The Social Security Code provides right to the central government and the state government to frame and notify the social security schemes for such workers on the matters related to life and disability cover, accident insurance, health and maternity benefits, old age protection, fish schemes may be funded by the government, central government, state government, aggregators, beneficiaries of the scheme, or funded from corporate social responsibility. So what we understand here is that the Social Security Code 2020 has given power to the central government and the state government to bring in all categories of unorganized workers to derive benefits by framing schemes, social security schemes, so that their insurance is covered, their life is covered, their disability is covered, their health is covered. They are also given maternity benefit. So the court places an obligation on the central government to constitute National Social Security Board for the welfare of the unorganized workers. Like I told you earlier, under the Building and Other Construction Workers Act 1926, there is a welfare board. Similarly, on those lines, after this law comes into being, all those laws will be automatically become redundant. So as per that law, even the code on social security obliges the central government to create a national social security board for the welfare of the unorganized workers, as well as for the gig workers and platform workers, and can recommend and monitor the schemes for such workers. The central government will have to set up and administer the social security fund for the welfare of such workers. Such fund is to be derived from employer's contribution, employees' contribution, state government contribution, central government contribution, and contributions from the companies as under the concept of corporate social responsibility. The code also gives right to the government to set up helpline and such facilities center, etc., for such workers. This will encourage the youth to participate in such jobs and can avail the given benefits. So finally, to conclude my presentation here, I have to submit here that the unorganized workers in India are in large numbers, up to 93%, meaning that only 7% of the workforce are in the organized sector and deriving all the benefits of wages, of compensation, of social security, of welfare under the existing laws. To overcome this difference between unorganized and organized workers, the new Social Security Code has got a revolutionizing provision to include all kinds of workers: domestic workers, auto drivers, barbers, home-based workers. Now, all of you are aware during the lockdown 1 and 2, how much these people faced problem. Those who were in the organized workers sat at home, worked from air-conditioned chambers under the fan, got their salary, got their social security. But those like migrant workers, domestic workers faced lots of problems. Therefore, we must see in coming days, once the rules are framed under the Social Security Code 2020, we will find that the problem of social security for the unorganized workers to a large extent shall be solved through appropriate rules that are to be made. Final words. We must appreciate the International Labour Organization, which has taken up several measures, including that of providing social security for the new kind of unorganized workers, the gig and the platform workers. The International Labour Organization has compiled a study on the gig workers and platform workers. And the conclusion of those studies are startling, that it says that maximum number of gig and platform workers are youngsters of the age of 25 to 35. That means of the age of 25 to 35, the younger population of any country. Now, when this younger population of any country engages in such kind of unorganized workers, it is but the duty of the society, it is but the duty of the government to protect this youth, because these people cannot get jobs in the organized sector or in the government sector. At least to that extent, they are not burdening the government. Therefore, it is the collective duty of the government and the society to look after these young and to be protective, because you cannot change the nature of employment. Globalization, technology has made it possible that several kinds of workers may come up. We cannot have a separate law for each kind of work. So therefore, the new Social Security Code 2020, along with its mandate by the International Labour Organization, I'm saying may because once it is implemented below, may uplift the rights of the unorganized workers as a human right. Thank you very much.
Yeah, any questions from participants?
Okay, if there are no questions, if I believe that the maximum number of students are participating in this webinar, my advice to the students of law, especially labor law, is to take up labor law studies and to understand its history from the perspective of workers' rights. Because if you go back to the history of workers' rights, it has not come about very easily. Even in the context of the Indian workers, Indian working class, they struggled a lot to get the basic minimum working conditions. Thanks to the philanthropists of those times, thanks to Dr. B.R. Ambedkar, who himself organized a party by name the Indian Labour Party, where workers' rights were put into the forefront. Thanks to Dr. B.R. Ambedkar, that when the Constitution was drafted, there was enough provisions to protect workers' rights, be it Article 16, be it Article 17, be it Article 23, be it Article 41, 42, several such articles gave assured measure to the workers that their rights, because they fought for independence of India, they fought in the Second World War. So therefore, they are assured of certain basic freedoms that they're entitled to. So when you study labor law, look it from a worker's perspective, and then you can debate on it as you grow in your life. Thank you very much.
Thank you, sir, for your enlightening words. Now I would like to propose the vote of thanks. Vote of thanks.
Any questions from a student side?
Yes, sir.
Questions from a student side. Any questions, doubts they are having?
Participants, if you have any questions, can you please drop into the chat box? Any questions from the participants? Please feel free to post it in the chat box. I think there are no questions, and I think the participants are all clear with the concepts, and they have understood the concept in and out of the topic.
I hope so.
Yes, sir. So I would like to propose the vote of thanks now. Being grateful does not mean that everything is necessarily good. It just means that you can accept it as a gift. Roy T. Benetton. First and foremost, my heartfelt thanks goes to our management for permitting us to organize this SCL webinar series. I would like to thank our resource person, Professor Dr. V. Sudesh, former principal, chairman, and dean, University Law College and Department of Studies in Law, Bangalore University, Bangalore, for enlightening us on this topic of social security and of unorganized sector. Thank you, sir, for providing us a clear framework on the special laws designed for unorganized class of workers and for throwing us light on the new Social Security Code 2020. Thank you for enlightening us more on the different kinds of workers who come under this category. I would like to thank our beloved principal, Dr. B.P. Mahesha sir, Principal, Soundarya College of Law, for extending his support, as always, to conduct these webinars. Thank you to all our faculties for their continuous support to plan to execute this webinar into a successful one. I would also like to thank our IT department, sir, Mr. Prasad sir, for technical support to run this webinar smoothly. At last but not the least, I would like to thank all the participants for their active participation in this webinar, even though having their exam schedule. Participants, please fill in the feedback form given in the link below. Looking forward to connect you with much more webinar series for more informative sessions. Thank you all, and signing off now.
Just a moment, Priya. There's a question posed by the students in the chat box.
Yes, sir.
Just look at it.
So here Biresh has given a question saying that
I don't think it comes with Gram Panchayat is not our topic. if anything, I mean, workers and under gram panchayat, something like that, I can let him be specific, because he says, if any queries regarding to the gram panchayat, where can I ask? I don't know. I'm sorry. This is only about unorganized social workers. Okay.
Anyone else for the questions? Thank you, Viresh, for posing this question.
I can only say tell Biresh is that if he's talking about the Gram Panchayat employing workers under the Manrega, Mahatma Gandhi National Rural Employment Guarantee Act, even if a worker is employed by the Gram Panchayati, they still have to pay the minimum wage as directed by the High Court of Karnataka. There is no exemption whether you are employed by the Gram Panchayati or whether a private employer employing you. Insofar as fulfillment of the minimum wages are concerned, all are bound to pay the minimum wage. Number one. Number two, wherever, if there are, for example, service-oriented employment, you're employing a painter, you're employing a wood bender, something like that, then the agreements will hold good. Whatever agreement between the person who engages them and who works, the agreement will hold good. But for all other cases, it is the minimum wage law that has to be. So much so that even an employee, even a prisoner who is employed by the government to carry out certain prison activities, even that prisoner is also entitled to minimum wage. That's because he's a prisoner, he's a criminal. You cannot escape by not paying the minimum wage. So much I can say. Thank you very much, and all the best to all of you. Thank you very much. Thank you, Dr. Mahesh.
Thank you, sir.
Priya.
Thanks a lot, sir. Thanks for your time.
God bless you all. And I wish you all
Thank you,
success for future webinars. Thank you.
Thank you, sir.
Thank you. God bless you.